My pleasure.
Thank you. And next meeting, we can go over president and secretary. Now I suggest we just continue with Don as president, and I'll take notes unless someone else volunteers to be secretary for this meeting. Hearing silence, I'll take notes and we'll move right along. So the agenda was knocked aside when I redialed back in.
I think the only administrative thing we have to do from the agenda is approve the meeting minutes from 2 years ago.
Yes. And Michael, did you have any, this is Michael Zimick, did you have any questions on what we did 2 years ago?
No, if you need a motion, I'll make a motion to approve the minutes. I don't know if we can with just the two of us. But
right. And of course, Adam, you weren't there, but I suggest that you move that we approve it subject to Don chiming in, unless this is a technical point of order for Michael Marcello. Since we have a quorum, only Mr. Zimick and myself were present 2 years ago. It was really Don who was the third person who was not here. Having a quorum here, is that enough to approve the minutes of just the two of us? Or
even though Adam wasn't there, the board continues. So yes, that's fine.
Yeah,
based upon your representations that you believe they're accurate, I think Adam can fairly vote.
Yeah, or abstain. It's up to you.
Yeah, exactly. Yeah.
Sure. So I guess, Mr. Zimick, the motion to approve?
Sure. Yes.
Okay, I'll consider that ongoing. And let's take a roll call. Mr. Zimick, do you approve?
Yes.
Okay, I do too. And Adam, do you want to vote yes or abstain for the minutes of 2 years ago?
I'll abstain. Thanks.
Fair enough. So noted. Okay, let's move on to the business of the meeting, which is with is it Gallantly? How is the name pronounced? The petitioner?
I can bring him in. Hang on.
Please.
It's Bruce and Colleen, I believe.
And the last name is pronounced how?
I believe it's Gallaty. I'm not sure. We'll have to.
Okay.
Hello, Bruce or Colleen. You can speak now if you unmute yourself. So there you go.
Yes, good evening. Last name is pronounced Gallantly.
Gallantly. Okay, thank you, Mr. Gallantly.
Nobody pronounces it correct.
Yeah. All right. And do you have someone representing you for this meeting?
Unfortunately not. Over the last 3 or 4 months, I've searched high and low, spoke to several, numerous attorneys in Middletown, Tiverton area, Providence, a couple of engineers, and everybody seems to be exceedingly busy. I'm able to take on new clients, so here I am.
All right. How would you like to proceed?
So I believe some or all of you may have a copy of the package that I submitted. Is that true? Or
yes, thank you. Okay. We've seen that.
So I'll just start off by saying first, appreciate everybody's time and consideration on a beautiful night. My wife and I purchased this property back in August 7th, 2019. And prior to purchasing the property, I had done quite a bit of research and inquired with the local building inspector. At the time was an interim building inspector, Coastal Resources, DEM, folks at the state, and also with another building inspector in the town of Narragansett, as previously we had another property in consideration. And everybody referred to the same code referencing the substantial improvement rule. So we, wasn't the primary reason, obviously, for purchasing the property, but so in the fall or early spring, I can't recall now, time's flying, but I reached out to Bill to see, what the process would entail. And while I understand, at that time he came and visited the property and was of the opinion that what we were looking to do, which is we have an attached deck on the west facing side, the northwest side of the property on the water. About 192 square feet, the attached deck, been there for many, many years. And we're looking to enclose that square footage incorporated into the living space. So he indicated that there was a code at the building code, I guess, that prohibits that type of lateral addition or expansion of the footprint or expansion of the living space. So, obviously we're appealing in the hopes of, getting a variance or a modification to that rule. I've seen many different NFIP documentation and science matrices and things, and it's a very confusing code, but there are, in the FEMA NFIP code and the RISBC sections 23.27.3 reference, that 50% substantial improvement rule. If improvements made to the property do not exceed 50% of the value of the structure, that addition or that improvement does not have to comply with elevation. So in my discussions with various local attorneys that offices deal with land use and building code, the matters, there didn't seem to be many situations where they experienced, especially in the Tiverton area. So, kind of going based on what, some have said, the deck is part of the footprint. Others have said not. We're not looking to exceed the deck footprint. It doesn't encumber on any of the setbacks. Will allow us to accomplish a couple of things. Obviously, it's the most reasonable way to expand living space, but it'll also allow us to reconfigure and take some of our utilities out of the basement, which is obviously a higher risk area, such as the washer and dryer, things of that nature. So, while I'm not an engineer, I understand there's concerns, about, dispersion of water, dispersion of flood waters and things of that nature. So, based on the way it's configured now, if the water came up, it kind of get caught in that alcove area, for lack of a better term, versus if we're basically just looking to connect the corners of the north side of the property with the west side, and connecting that corner by closing that deck. So, looking for a variance to this, I guess, rule in the RISBC R322.32, which requires elevation.
Are you only adding on to the first floor?
Yes. Yes.
And that's in your, I'm looking at page 13 of your submittal, your application, and it looks like it's about an 8-foot addition to the living room with a fireplace and a stair up to the second floor deck on the back.
All right. So yeah, just a note on those plans that I provided. There were in the file at the town, one of the previous owners had crafted these elaborate plans to do some additions to the property. And one area in particular they were looking to do is exactly what we're looking to do, is to expand that living space over the deck footprint. There's not going to be a fireplace in there. There's not going to be a stairway on the side of it. It's just, I tried to highlight in yellow the area that's being expanded. So, this is we're trying to get a determination on conceptually whether we can do this or not. But yeah, those were drawings from a previous owner, and I understand, if this thing moves forward, we gotta, get our own plans drawn up and permits and all that, everything being in building code compliance. So That was just, that was kind of a, useful information because they were looking to do pretty much exactly what we're doing. Now that deck space that we're looking to enclose, the family room roof has a deck on top. So we're just, there wouldn't be any living space above that expansion. It would just be a continuation of the deck. So no, additional, structural requirements, weight, load bearing or things of that nature, as far as I know. So
What percentage of the value of the addition relates to the cost of adding the addition versus the overall value of your whole house?
probably be around 30%, 25 to 30%.
Mr. Moore, do you have any comments or observations at this point?
Sure. So the property is located in a VE 20 zone, which means it's a velocity flood zone. And the BFE, which is the base flood elevation, is 20. This house sits at 10.5 feet, I believe, or 10.75 feet above mean high tide, which is, that BFE is 10.75. But the problem is the flood zone codes are very, very difficult between the 50% rule and all the loopholes, and then Rhode Island State Building Code. It's very, very difficult for people to understand how to give a straight and specific answer without a plan. So Mr. Galley did provide a plan that was approved previously to go to CRMC in my office, but it was a plan from 2006, which was a little while ago. I think the building code has changed at least 3 or 4 times since then. But that being said, it is very confusing. The 50% rule, it's clearly under a 50% renovation. However, the building code of Rhode Island does not allow a lateral addition without elevating it. So that's where we're at. And that's my interpretation through talking with at least 7 or 8 different people, building officials, and with the state. And I believe Mr. Gallatley discussed this with state officials also. So there is always, a little bit of an interpretation issue, especially with the flood zone, and especially not without clear cut plans. But I do believe he's right. He's definitely under a 50% renovation. I just don't believe he can have a lateral addition without elevating the addition. So that's kind of where we're at, I provided, a bunch of different codes. The one I cited him on was the R322, which is a Rhode Island State Building Code. The substantial improvement code that's in there, the 23-27-106, I think it is. That's also part of the Rhode Island State Building Code, but it's also a general law in Rhode Island. That's why it has a different type of number, but they're all part of the building code. And then FEMA has a set of rules too, and guidelines that make it less clear at times. Let's put it that way.
Yeah.
So that's where we stand, really. Mr. Gallatley would like to do an lateral addition. By the way, as you all probably know, a sun deck off the side of your house does not have to be at the proper elevation. It's allowed to be below BFE, and that's about it. I can't grant variances, so that's where we're at.
Yeah. Michael or Adam, any questions?
Has this,
I'm
In order-
guessing that this, oh, I'm sorry.
no, in order for Bill to, despite, depending on what we decide here, obviously, but in order for Bill to give you a permit, you're going to need CRC exception or some kind of administrative ruling, maybe even something you have to go in front of CRC because you're within 200 feet of the coastal feature. So has any of this been in front of CRMC?
Not enough formal as not as formal as it's being presented here.
Okay.
Bill? Moore?
I just wanted to make a comment. CRMC does have jurisdiction within 200 feet of all coastal features.
Right.
They normally don't get involved with building codes or zoning. They really only want to know how you're treating the land and how you're going to create, erosion issues and not create.
Right.
Issues.
In my opinion, he's making a permeable surface, a deck that allows water to go through, impermeable. So they're definitely going to give you a ruling one way or the other. So if CRMC says no, then you can't give them a permit anyway, because CRMC is not going to allow it. So it's,
Right.
It's one of those back and forth things.
They would give them a permit, I'm sure.
Okay.
They always do, if you work at it.
Adam, you had a question?
Yeah, is the deck getting completely demoed and a new poured concrete foundation wall going in its place? Is that your plan?
Whatever the code requires, whether it be, a foundation or pilings, whatever whatever requires compliancy in the building code.
You're not using the existing deck as a floor.
No. I don't think that would be code compliant.
Right.
So it comes back to the current permeable surface is going to become impermeable.
DN doesn't consider decks permeable, though, right?
Oh, they don't?
consider a deck permeable.
Oh, I figured they did just because the water.
No,
can go
for some
through it.
reason they don't, right? Because water runs right through, you would think, but I guess it has to do with whatever compaction takes place underneath. They don't consider it permeable.
Okay.
Let's see, any further discussion or questions? And Mr. Marcello, have you dealt directly with this issue in other towns?
No,
Rhode Island.
no, because I live in Situate, so we don't have a lot of ocean front where I live.
Fair enough.
You're in trouble.
But except the reservoir, I just for the benefit of the board, I just want to cite the section 8-35 of the Tiverton Code of Ordinances, and let me just read it to you. It says, the board may vary, the board meaning you, the board may vary the application of any provision of the building code to any particular case when, in the opinion of the board, the enforcement of the building code would do manifest injustice, provided that the board finds that the decision to grant the variance or modification will not conflict with the general objectives of the building code. I think Mr. Moore was being very honest when he indicated that he did not believe that he had the ability to grant a variance based upon the current state of the law. And I believe that based upon my review of the law, I believe he's correct in his initial determination. But the reason why we have boards like this is to, obviously make exceptions when we believe that the exception, strict enforcement of the building code would do manifest injustice. So that's kind of where we're at. Now it's up for you, the board, to decide whether or not the applicant or the appellee has met the burden.
So this is being considered an addition, not just a modification of something existing? This is just being labeled as an addition to the house?
I think that question is better addressed to Bill, but I think he considered it.
Well, yeah, I was asking Bill.
Oh, I'm sorry, Adam.
Sorry.
Yeah, yes, it would be a new structure, right? And then if the board did grant it, because it's an under 50% renovation still, you're in the V zone, that's pier construction. I don't know if you'd have to build it on pier construction or not. It's still under 50%, which means you don't have to follow the exact code.
This could not be considered a modification to existing, considering it's the same footprint, identical.
No, it's
footprint?
going to be a brand new structure. The deck's going to leave and you're going to
Okay.
put a new support in. So what's going to be there that modifies? The only
Okay.
thing you're protected with is the footprint, It
Right,
is a
right.
footprint, right? That it definitely is a footprint. It's just not living space.
Right.
Yeah, I would think it would be considered an addition.
Okay.
And this is, not for nothing, FEMA and the velocity means flood with wave action. So that means you're going to have a scouring action. So you have in the FEMA maps, you have different levels and different elevations, and the V stands for wave action. But those maps, and I want to say 10 years ago, Adam, you might know better. They underwent a whole, like,
I know they
early
did.
in
My
the
wife's in the
60s, they
insurance,
finally
yeah.
updated them in the 90s, 2000s, and they changed
Right.
everything.
Mhm.
So if you drive down Riverside Drive,
They're
if
modified
you had
regularly.
an event that was above that at the FEMA levels, half of those houses are gone, or more than half of them. And if you look at the Zillow listing for Mr. Galilee's, I mean, he's already got a kitchen with stainless steel appliances, you know, the money's on the first floor. And the whole 700 square foot first floor is in violation. Or what's the wonderful word that we're like, unconforming, you know, non-conforming lots, something like that. It's a non-conforming building. But it was built at a time where that might not have been in the V zone, because the V zone might have changed. I don't know that. I just know that there have been updates to that. So you just might want to keep that in mind. I am totally in agreement that right now, Bill can't give him a permit because he doesn't know what's actually happening out there. We don't know if we're building a foundation, if we're building piers, because we don't have data, right?
Well, I really can't give him a building permit because he's not going to elevate it to the
Right.
proper height.
I understand that. And I
why I
guess
can't
my
do it.
personal thing, I don't have a problem with that because none of it's elevated. And the house next door is not elevated.
Yeah.
And the other house next
Right,
door.
Well, the
I'm in the
house
same-
next door is.
I'm in the same mindset. The elevation is not an issue to me. I guess it's the fact that you're adding something that is not going to comply. I guess the lateral addition is illegal right now for some reason.
And I didn't see, I was trying
Even
to
though,
find
the
that.
footprint is identical, that's where I'm getting hung up. It's a lateral addition, but the footprint is already there.
I add a little bit.
Please.
So one of the references I mentioned that I'm looking at right now, it's in the IP desktop, you know, the reference guide that references talks about substantial improvement and things of that nature. And there's a particular table 6-1B compliance matrix for V zones. And obviously our property is a pre-firm building, and it specifically says the type of work, lateral addition that is not substantial improvement, addition not required to comply. So that's just, you know, one of the things that, you know, I've read in my research, and you know, that lends, you know, to the there being a lot of confusion about, you know, which code supersedes another or this, that, or the other. And additionally, that addition, none of our abutters would even see that, so it wouldn't be blocking anybody's view. It wouldn't be encroaching on anybody. We have 25-foot hedges on the property lines, and not encroaching on the setbacks as far as we know. Again, you go back to it being the most reasonable way to add some living space. The only other option would be to elevate the house, which would be, I got an estimate of 130,000 plus to just elevate out of the flood zone, which obviously wouldn't want to do. Number one, wouldn't look very appealing, and number two, it's, you know, financial hardship, obviously. But just think it's, you know, really the most reasonable way. And on that north side of the house, there is there's a small extension that's the first floor bathroom. And I was thinking, you know, so we wouldn't be exceeding that line if you drew that line all the way east to west on the north side there, and then, you know, meeting up with not extending beyond any of the lateral lines of the property. So just
Bill, where was this lateral addition thing that you were talking about?
So the code R322.3.2.
Yep.
Which is on the sheet I sent you. Julie might have sent you today.
Yep.
I
got the book here too.
Right. It doesn't say lateral addition. By the way, just so you know, FEMA's regulations and guidelines allow a lateral addition. Okay. It's the Rhode Island State Building Code that does not. So that 322 code requires it to be elevated. FEMA does allow it under a 50% renovation to do a lateral addition. So that's what makes it difficult and not clear.
Well, I guess I read 320. One of the things to me about a building code is, and this is for Doug and Adam, this is my interpretation for what it's worth. It's for new buildings. So if you were building a brand new building, you'd have to elevate it. And it might look ugly and it might not work. You'd have to elevate it. When you do additions, the addition is supposed to meet code as much as possible, energy code, structural code. And even if they've increased, you're supposed to, and that's where you get to that 50% threshold. If you hit that 50% threshold, then you have to bring the whole structure up to code. That's kind of how I've always interpreted it. So to me, it's like you could go ahead and do this until you hit the 50%, and then you should lift the house, and then you should fix everything, right? But if you're just doing these additions, I guess that's kind of how I always represented this code. So this 322.1, where it says buildings and structures erected within high coastal shall be elevated. To me, that's for a new structure. If there's a structure that's been sitting there for 100 years and it's not elevated, at what point do you make an owner elevate it? When they hit that 50% threshold, and then the whole structure. And that's not just, Mr. Garrity, that's anybody, and anybody doing a commercial facility or whatever. As soon as you hit that 50% threshold, the whole thing's got to come up to code. And that is, as Bill's right, it's a point of contention in the state, because we also have this wonderful thing called existing building code, which is a pain in the ass too. So there's a lot of things that you can pick and choose from. So that's just my 2 cents about how I feel about this particular code and that particular statement. So that's why I was asking where the lateral came from, because I never heard of that before, a lateral addition. So to me, an addition is an addition, whether you go vertical or horizontal. It's an addition.
Well, a vertical addition would come under a different type of criteria
Okay.
if you were going up.
Adam, any further questions or thoughts?
No, I'm in the same, I'm in the same mindset as Mike. This is just a small modification, in my opinion, to the existing footprint. It's a small addition, small modification. Yeah, I don't take issue with what he's requesting at all. I mean, obviously, there's a lot of stuff missing. You need plans and all that. But as far as him asking what, it looks like he's asking for permission. For me, I mean, I'd give him permission if it was up to me.
Mr. Zimick?
Do you want me to make a motion?
Sure.
Because I would move to allow him to do the addition in that location, but I would be pending upon approved code compliant plans,
Right.
which we don't have. So it's tough for us to say, go do it, because we don't know what you're going to do.
Well, he's not going to be able to do it without a set of plans regardless.
Right,
We can
right.
say, okay, go ahead. He still has to bring us a legitimate set of plans.
Well, I don't know if he has to bring us, but
Well,
he has to
I'm
bring
sorry,
Bill, and then Bill can bring it back
Bill-
to us
Right.
if Bill doesn't like the plans,
Right.
if he doesn't feel the plans are to code.
Right.
But in terms of the elevation idea, I think we could, I so move that we give him relief from the elevation requirement. Is that how you want me to make the motion? Go ahead.
Bill?
I think.
No, I just wanted to mention, that's great. Just don't say code compliant plans
Okay.
in your
Mhm.
motion, okay?
Everything else but that one. But 322.3.
But as I'm hearing the motion, it's basically allowing Mr. Gallatly to go to the next step. It's not saying, sure, do what you want. It's basically, it's
Correct.
freeing up Mr. Moore to now work with Mr. Gallatly to come up with the appropriate set of plans and approve them according to code.
Yes.
According
And again,
to
if
what
you
makes
want me to
sense.
move to give Mr. Gallantly relief from R 322.3.2, I can say the motion that way. That does not relieve him from the rest of this book here.
Yeah, does that
Okay.
work for you, Bill?
That
Yeah.
sounds reasonable.
All right. Okay, so moved. Adam, you want to second it?
I'll second the motion.
All right. Let's poll because we're in a Zoom meeting. So we'll start with Mr. Zimick. Are you in favor? Yes or no?
Yes.
Okay, yes. Adam?
Yes.
Yes. And myself, Mr. Denninger also says yes. So it's a unanimous approval of relief from that particular elevation requirement. And now, Mr. Gallatly, you can go on to the next step.
Well, I appreciate that very much, gentlemen.
Good luck, Bruce.
Okay.
Been a long road, but I appreciate the time and consideration.
Well, thank you
You did it.
for all of your time.
And you did a good job representing yourself without a lawyer. So there you
Thank you. Saved a few bucks.
go.
Okay.
Bill wants you to put it in the plans now. That's how Bill's going to tell you, right? You
Yeah.
got no lawyer, put it in the plans.
There you go.
All right. So for additional, I guess that's concluded. Any other business, new or old, to address tonight? Adam, you want to move to adjourn?
Yeah, I'll make a motion to adjourn.
Okay.
I'll
I
second.
All right, and I guess all three of us are in favor. And Mr. Cotta, thank you for participating as